James, let's talk about the government's best argument for convincing the appeals court what they want to do, which is they have the right to invoke this 18th century wartime law, the Alien Enemies Act, and that it has been used appropriately. What will they be saying to this three-judge panel?
Well, the government will be saying, as Lisa just indicated, that the wartime powers granted under the Alien Enemies Act apply in the context of Venezuela and in the context of Tren de Aragua. Now, that is an extraordinary reach. Which is to say, 3 times in the nation's history this has been invoked: the War of 1812 and the 2 world wars. Whatever one's view of Tren de Aragua or of foreign relations with Venezuela, we are not in a situation that is remotely analogous to those 3 circumstances. And so, in a sense, this case is either extraordinarily narrow. It's about individualized, granular determinations as to whether the act applies to particular individuals, whether those individuals essentially have what in the Guantanamo enemy combatant context we used to call combatant status review tribunals. The opportunity to have an individualized hearing to determine whether or not the act applies to them. There are individuals, and there are attorneys, obviously they have a partisan interest in representing their clients, but who are asserting that individuals who have no relationship whatsoever to Tren de Aragua have been caught up in this, which is why we have due process, even for non-citizens. It may not be the full scope, all the bells and whistles of the trial by jury, certainly not, but the opportunity to have an individualized determination. So the government is arguing, in essence, to really get to the heart of your question, that this is a circumstance in which the foreign government, that Tren de Aragua is essentially a hybrid, indistinguishable from Venezuela's foreign government, and that therefore the act applies. If that argument prevails, then this case is incredibly broad and opens up an extraordinary opportunity for expanded executive power.
But tell me, James, how much will that rely on interpretation of opinion versus hard fact?
It's a good question. And in today's opinion by Judge Boasberg, he actually pulls back from making a judgment for now on whether that is a political question that is beyond the judiciary's reach and is solely the executive's. But he says, look, he essentially says that question is one we may have to address down the road, but it's not a clear case. I mean, 75 years since this has been used, this particular act, that's for a reason. We haven't declared war for 75 years. This is to use this act in the current contemporary context is a dramatic expansion of executive authority.
So we've heard multiple officials, Christy, and that includes the president, who's arguing that this man we see on screen, that was Judge James Boasberg, everybody, that he's essentially trying to take the power from the president, usurp it from him, and then help to dictate foreign policy as a result by his rulings, by what he is saying. Is there a legal argument for that, or is this the kind of thing that's being made merely to appeal to the court of public opinion?
The latter.
Okay.
That's an argument for the court of public opinion. Actually, if you look at Judge Boasberg's order from today, he was very careful to say, I'm not actually deciding the issue of whether this proclamation from the president is lawful. That's a thorny, complicated issue. These are hard questions. Even during his hearing, he took pains to say, I'm not deciding on this yet. I may actually come out in the government's favor. I'm not sure. I need more time. I need more briefing on that. But where the law is clear is that these individuals are entitled to due process to decide whether or not they actually fall under the proclamation, whether they are members of this gang. There, the law is clear, and so on that due process ground, I'm going to have these temporary restraining orders continue in place. I'm not going to vacate those. And so it's a very narrow order that, again, is just there to preserve the status quo. That's all he's trying to do. He's not ultimately deciding on the merits yet. This is temporary. And I think he's really taken such pains to, be that narrow, be that clear about the fact that he's not trying to go too far just yet. And so when you see in the media the Attorney General referring to him, as a radical left-wing lunatic, and he's trying to take the place of the president and dictate foreign policy, that's just not at all what is going on in that courtroom.
Got it. John, reaching out to you now, because the Time magazine published an account of these experiences of these detainees once they had arrived in El Salvador. Here is part of it. I'm going to read part of it. Here it goes. After being shaved, the detainees were stripped naked. More of them began to whimper. The hard faces I saw on the plane had evaporated. It was like looking at men who passed through a time machine. In 2 hours, they aged 10 years. They entered their cold cells, 80 men per cell, with steel planks for bunks, no mats, no sheets, no pillow, no television, no books, no talking, no phone calls, and no visitors. For these Venezuelans, it was not just a prison they had arrived at. It was exile to another world. So there are going to be many Americans who may read that and say, who cares? They are gang members. They get what they deserve. What do you say to that?
You know, Alex, I think that is one of the most remarkable pieces of this story, and one that I think the court's going to be exploring in further depth as this case goes on. This is not like any deportation I've ever seen before. Typically, the United States, when we deport people, we send them back to their home country. There are times when maybe they've been charged with a crime in their home country and they might get detained. But by and large, we're returning people to their home country where they're then allowed to walk free and return back to their family. In this case, we deported them to a third country, El Salvador, where we knew and had arranged for and arguably paid for their incarceration. I think there are still a lot of questions about the nature of that relationship, under what theories El Salvador are holding them, how long are they being held for. But I think in many ways, that fact alone takes this case. The question is not just whether these migrants were entitled to the basic and more limited due process we provide migrants before we deport them, but whether, and if not, we're bypassing other constitutional rights for them as well, given the fact that the El Salvadorans are incarcerating them at our request. Historically, the INA does allow us to deport people to third countries, but it is very limited, very rarely used. The first Trump administration did it in a completely different way at the Mexico border, where they would return to Mexico certain, non-Mexican nationals who would come into the United States seeking asylum. But I've never seen anything like this, where we've arranged for mass incarceration in a foreign country and return people there without any process at all, knowing, in fact, intending for them to be imprisoned in that country.
So when typically these trips will happen, the deportations, John, they go back to their home countries. I mean, what percentage of deportations, you send them to their home countries, they're repatriated, they've gone through all of the due process, every I is dotted, every T is crossed?
Yeah, Alex, the overwhelming majority of migrants who are in this country, of the 11 to 12 million migrants who are in the United States, the vast majority cannot be deported unless and until an immigration judge has had a hearing. And the reason is, Alex, of course, there might be claims to relief. And that's another question we don't know about these 300 Venezuelans who were deported. Where were they in the process? Almost all of them were certainly asylum seekers. We don't know if any of them have been granted any sort of relief by an immigration court or any sort of protection from deportation. And there's another issue, too, which is that the United States, we do not deport people if they are going to be tortured when they're returned to their home country. So we have we're signed on to the Convention Against Torture, and we extend what's called withholding or removal. So if you're a migrant, you say, hey, look, I have no right to be in this country, but you can't send me back to this country because I'll be tortured there. You can receive a stay of removal, basically, be granted withholding, be allowed to stay in this country. Had these migrants had an opportunity to make that claim, it's very well they might have succeeded, given the conditions in the El Salvadoran prison. So again, the rushed nature of this really raises thousands of questions. And because the administration is not giving answers right now, it's really hard to know, how in many ways egregious this process was in terms of the rights that historically would be afforded that were deprived for this particular group.
Christy, to you then. Pam Bondi says this is heading to the Supreme Court. Do you agree with that? And what happens when it gets there?
So it seems certainly like that's where it is headed. One thing that is remarkable to me is that Pam Bondi, as the Attorney General, continues to attack this judge. And if it is going to the Supreme Court, and I agree with her that it probably is, Supreme Court justices, I don't think, like it when you personally attack the district court judges. Judges generally tend to have each other's back, at least with that in that regard.
John Roberts doesn't like it.
Right. John Roberts, we saw make a very rare statement saying you shouldn't be talking about impeaching judges. That's not how we deal with disagreement. We deal with disagreement through the appeals process. And so, by continuing to fight this in the court of public opinion, it's really not doing anything to advance this legally, I think. I think if anything, and I expect even at this hearing today, you have 3 judges who are going to look at these filings. And as Judge Boasberg said, the filings, I've never really seen anything like this before. They're really disrespectful. They're really rude, calling this petty mismanagement, and you're fact-finding and you're asking for immaterial facts. Well, that's not really for the litigants to decide. The judge can determine what he thinks is material and what he needs to know about whether a court order has been defied. So you're already kind of putting aside the merits, starting out in a very, I think you're putting yourself at such a disadvantage by behaving this way. The government is always supposed to be ready, but always supposed to be respectful. And so when this heads to the Supreme Court, I don't know that the government's reception is going to be one that they would expect.
Which brings me to the question to you, James, which is, why do you think they are fighting this act this way so hard? Why not just go through the normal procedures and do it by the book?
It's a really, really good question, and I think it comes down to Machiavellian strategy, which is to say the real challenge, if you are, as the administration clearly is, inclined to, let's say, deport 11 million individuals, the real challenge is one of resources and capacity, and that includes resources and capacity in terms of the immigration judges needed to have those individualized hearings that John was referring to earlier. And so if you can succeed, if the government, the Trump administration can succeed in using the Alien Enemies Act in the way that they are purporting to use it now, then you are basically giving the executive branch carte blanche to get around all of those resource constraints that normally apply. This would be a dramatic expansion of executive authority and a huge reduction in anything resembling a check or a balance.